Good morning. I'm John Casper with the Oshkosh Chamber. Our pleasure to do a remote breakfast briefing. This is a BYOB, bring your own breakfast, to this breakfast briefing. So I hope people who signed in are doing that. We have a program today with, again, our good friends at Von Briesen and Roper on security breaches and privacy issues in the workplace. So you're not here to talk to me, but to hear these professionals talk about that. And I'm going to throw it over to Jim. And there hasn't been much happening since yesterday, Jim. So I hope you can find some things to talk about. So
I think we will. And good morning, and thanks, John. Always a pleasure, and to continue our series with the breakfast briefings. My name is Jim Macy with Von Briesen and Roper. I'm joined today by one of my partners, Jonathan Iden, also from Von Briesen, and Chad Hayes, who's with Set Off Recycling and Data Destruction. And we thought we'd do something just a little bit different, thinking people might have been COVID-19'd out, and from an HR standpoint, expand back into the breakfast briefing series and do a different topic. So today we're going to talk about security breaches and privacy issues in the workplace, different things very specifically that Chad and John have been working on in different litigation, and also becoming more current and really forced all of us to get much more into this realm over the last couple of months. Before we do that, though, we'd be remiss if not talking about what happened a little after 4 o'clock yesterday, and that's with the Supreme Court decision in Wisconsin coming down that overturned. Now, I want to be clear about this. This is not overturning the governor's order, because it wasn't a governor's order that was in dispute, but the secretary's order that had to do with the closure and the safe stay-at-home order. As far as that goes, if I took just a minute in regards to that, the Supreme Court did find that Secretary Palm broke the law when she issued Order 28, and she failed to follow the emergency rule procedures. It's one thing to have an order and a rule, or rule depending on what it was, and in this case they found it to be a rule, which means different procedures apply. But it's another thing to not follow the rules in doing that. They also said that even if there was not a problem with the emergency rule making, she exceeded her authority with all the specifics that went into that, ordering people to stay home, closing essential businesses, prohibiting private gatherings, and forbidding all non-essential travel. They specifically addressed each of those kind of things. What's interesting, they did not grant the stay that the legislature was asking for. They asked for several days so the groups in Madison could get together to determine what to do. And the court said, you know what, we've been discussing this for 12 days. You folks do your job. Don't put that on us, and get together and help the people in Wisconsin. So here we are. We'll talk about this tomorrow in a different briefing. Go to the chamber website, but we'll get a lot more specific about this. But thought you ought to have an update for now. It's up to each county to determine what's going to happen, so stay tuned. Let's go to today's topic, though, without any further ado on that. In terms of topics we're going to cover today, we're going to talk about recommended handbook policies related to email and computer usage. We're going to talk about policies and procedures to protect confidential information, best practices in avoiding email attacks, and best practices for providing and securing remote work locations. Again, everything that we were sort of, if we didn't have things in place before, if we didn't to the extent what we should have, we will now, and we're certainly moved that way over the last couple of weeks in that regard. Not to say, and just in terms of what Chad and Jonathan are going to be talking about, but litigation over what happens when the protections aren't followed, when people steal our material, and do we have things in place to help provide or prohibit those kind of things, and then what do you do if it does happen? Let's talk just briefly for a second about handbook policies and what that should include. Everybody should have something. Well, first of all, you got to have a handbook. Everybody should have that, but separate of all, you should have something in your handbook about these type of things. And how can you use things that are provided by the company? What hardware do we give? What email accounts? Who's using the phone? Yesterday, I'm on the phone with a client that's got a concern with evidence that's on a phone. They just pay the employee a stipend a month so the employee uses their personal phone, but also uses it for company business. Do you have that addressed in your policy, and what's your right to get that information? And how do we talk about those kind of things? Different things for your checklist to be in that policy. Similar to when we go back to the older cases about lockers and tools and other things, is the idea that who owns it, and you want to make it really clear that you own your property, and that taking of your property, including electronically stored information, that's yours too. And that somebody taking that, using it at their next place of business may be theft. And these guys are going to talk about that in a minute. Using our equipment should be work related. Do I see policies that say there might be a few minutes of this or that, or we're checking with home to see who's bringing home the milk? We get that. But at the same time, you want to control, and things ought to be primarily or almost exclusively work-related in that regard. Is the email account really for business, or are you doing a shared account where the employee's using their personal account? That's problematic, and you really should have a company email account with work-related things limited to work-related things. So are they spying on me? Can my company spy on me? Can you spy on your employees? The answer is yes, you can. And it's not illegal. It's your stuff. Do you have time to regularly go through all of that and do it? Of course you do not. But there is no expectation of privacy. There's nothing wrong with saying there's no expectation of privacy. And that's something critical that you need to put in policy and let people know that that could happen. And they shouldn't expect that if they're having an affair with the neighbor and they put it on our stuff, yeah, we may find out about that. And if it impacts our company, they may not be working with us any longer. Let me turn that over to one of the other guys and we'll pick up from there.
Thank you, and let me know if anyone can hear me already. I do believe we have the chat open, so if you have questions you want to ask while we're going through the material, please don't hesitate. But as Jim mentioned, the first starting point for any employer is to establish a policy, and the point of this presentation, while I think most employers have a handbook and probably have some form of a social media policy, the focus and the goal of this presentation is to provide you with a better understanding as to why that's important for purposes of protecting your confidential information. We have Chad Hayes here, who's an IT expert and professional by trade at local business here in town, State Off Iron, and also runs his own consulting company. And he's going to provide the technical side of the equation. So I'm going to explain to you why it's important to protect the information. He's going to give you some of the IT basics to at least have that conversation with your internal IT professional, or if you're working with a third party, you'll have some common vernacular or some verbiage to use with them to say, I've heard about a VPN, I need to know more, and can you help me? Now, in this day and age, companies are going more and more digital with their information. I know at least in our law firm there, if you have a piece of paper on your desk, you better hide it because they're coming for it. They want everything electronic, and I think most people are going that way. Likewise, with the pandemic recently, but even going back several years, we were seeing more and more companies offering the ability to work remotely. It was a huge push for recruiting when unemployment was 3.3%. Wow, 6 months ago, what a change. But we're seeing younger generations and younger professionals want to have that ability. So employers were already starting to look at remote access issues, and now that is just pushed to the forefront with everything that's going on. So how do you address these issues of security and establish the correct infrastructure? That's what Chad and I are going to talk about. And from a legal perspective and protecting the information, your policies and your internal procedures really drive how well protected you are when you start to expand the area out of your control. You have your brick and mortar establishment, you have your desktop computers and your filing cabinets. That's not the modern workplace anymore. Everyone is going to be on laptops, working from home, working from public Wi-Fi networks. And what do you need to have in place in order to make that transition securely? So focusing on email, first of all, you want to have a well-established email protocol. Maybe this is too detailed for your employee handbook, but it certainly should be something that's in a policy format, memorialized in writing, and circulated to all employees. And the policy should address where to save project-related emails. So you have a number of employees who want to have joint access to information. You have a project manager or a lead contact that's receiving email communication into their email account. What is the storage protocol or the saving protocol? So that goes into a shared network where other employees can access it. Throughout this presentation, you're going to hear me talk about kind of security and access. So where is it coming in, and is that location secure? And then how are other employees granted access, and how do you govern those two components? Backing up the email account, is that happening? How often is that happening? How are you setting the procedures and the protocols for backing up your email account? Is that something that's happening automatically, or requires an individual to actually go in and execute a backup? Instructions related to work-related emails. It should be clear to an employee when they should and should not delete information. How long does it have to be preserved, and what can be deleted? And then prohibiting forwarding emails to a different account. Again, you want to control the access, and limiting work emails to work email accounts is a great first step to avoid the dissemination of that information outside of your email account. So with those policy recommendations, I want to just lay some groundwork on setting up a secure email account. And I want to ask Chad to address, first of all, the basics, just briefly discuss the difference between an employer's email account that is managed by an internal server versus an employer using a third-party cloud-based email account service.
Sure. Thanks, Jonathan. Good morning, everybody. My name is Chad Hayes. I'm the CTO for Sadoff Iron and Metal. And I also have a consulting company called Livewire Communications. Thanks for having me this morning. As far as the question at hand, as far as the difference between an on-premise server or a company-owned server and signing up with a Google or a Microsoft in the cloud, there are several things. I mean, on-premise server allows you to manage everything down to, the basic user who's accessing it. The cloud also allows you to do that. On-premise, we're seeing a lot less in the industry because it's becoming more and more cost-effective to put things into the cloud. As you move things to the cloud, everything goes to a type of pay-as-you-go type of thing. So if you want to have this type of access, you pay for this. It's more of a licensing fee than it is if you have an on-premise server. There's a balancing act between the labor that you have to put into managing an email server and the labor you have to put into managing a cloud-based. Both can pretty much do everything else the same as far as security goes, but there are things that a cloud-based gives you more than what an on-premise can. It saves you money. It saves you in IT costs. If small businesses don't have IT people on premise, a lot of times they look to consultants to do that. A Google type email system or a Microsoft email system is a little bit easier to manage once it's set up than, say, an Exchange server on premise. Backups and things like that are usually, depending on what licensing you get with your vendor, is usually included with a cloud-based product. Whereas if you have an on-premise product, you have to make sure that you're backing that stuff up, securing that, and also securing the server itself. As far as who builds, the server, who has access to that server itself, instead of, who just has access to email through the cloud. And
thank you. That's a good summary. And the analogy that I have in my mind as a non-IT professional and just a layman in this field is someone securing their money at home versus someone securing money in a bank. There's additional control, and you have it within your physical, although this is somewhat virtual, you have it in your building. You maintain the server, you control the backups, you store the backups, and it is within your brick and mortar. There's a heightened level of control that comes with putting all the money under the mattress. But if you don't have proper security measures, if you have outdated hardware for your internal server, or if you're not staying on top of that server management, then there are significant downsides and weaknesses to your security compared to using a third-party cloud-based vendor who is managing a lot of that backup and security protocol as part of the service. Is that a fair analogy? I mean, maybe a
Yes.
round peg in a square hole, but
No, that's pretty much, yes, that's an excellent analysis. I mean, a lot of companies, especially small and medium businesses, see a cost return. You know, their return on investment is a lot quicker if they go with the cloud-based. They don't necessarily have to have a full-time IT person on staff to manage email. It's something that is easier. It is easier to manage. You don't have to worry about the backups. Security by default is turned on to a certain level, and then you can enact different security levels.
And as Chad alluded to, there are a number of vendors providing cloud-based email service. We're going to talk about partnering with reliable vendors, and Chad can address how to vet out some of those, some of the differences between the offerings. But each one, to reiterate Chad's point, comes with options for setting screening procedures or setting backup procedures. There may be an additional cost for some of these services, but the point is, even though you are going with a third party, it still remains highly customizable and secure depending on the size of the organization, or regardless of the size of the organization. So the next topic I want to talk about, we've now established a secure email. We have a backup procedure through the third party vendor. We have our phishing email filters in place through the third party vendor. And now everything is coming into our employer network. And we have written correspondence that we need to scan, and we have invoices that we want to scan and save. The next area of concern is protecting the world of information on your internal corporate network. And some of the basics to addressing this issue, you want to eliminate a single employee having access to information. Their email is one example. You want to make sure that it's backed up in their account, but then it's also shared in an open access or a shared access location to the extent it needs to be utilized by other individuals at the company. You want to implement procedures for centralized storage, as I said, in the network. You want to limit access to highly confidential information to certain employees. Chad's going to talk about, through applications and password protections, how you can manage employee access. They can get into the employer network, but where they can go and what they can see is highly customizable. And then from a legal standpoint, you want to take extra precaution with information that's classified or that you would wish to protect as trade secret. An essential element of establishing information as a trade secret, which triggers additional protections under federal law, an element of that analysis is that the information is actually treated as confidential. So if you have an open source network where you give your employees a general password, and once they're into the network, they can access all customer lists, all pricing information, all what you deem highly confidential and sensitive, if that's open to every employee in the organization, regardless of their need to utilize that information, you're going to have a hard time arguing that that is truly, in fact, confidential and treated as such. So Chad, on that point of kind of managing within your network, what are some of the options that companies and employers have for limiting access or keeping it within department or within proper scope?
Pretty much it's unlimited. I mean, when you set up your network, you can determine by user access levels who has access to what. What we've usually seen in most cases is companies have directory structures or places, file folders where, you know, in our company or in many companies, they'll have directory structures set up by department. So HR's has their own directory or place to store files. County's got their own place. Executives have their own place. And those are only allowed to be accessed by those people in those departments. Of course, we also know that those departments need to share files with other departments. So you'll have secured department folders called shared folders with a department shared folders. And then what we set up is usually like an open share. And inside there, you'll have the same thing. It'll look like all the other shares. There'll be like an HR folder, there'll be an accounting folder, and that'll be open to anybody to put anything in there. Pretty much what that sets up is that if you have documents that you want to share with anybody outside of your department that aren't confidential or things like that, you can put them in the open share. If you just want stuff that's going to be shared within your department, you can put it in your share. There's also other levels where, you know, executives want to share with other executives outside. Those things can be easily set up within, you know, the domain structure or within your servers. Security from a user access level is pretty easy to set up once you have that infrastructure put in place. So you can get down to the macro level of it, how to set up certain access for certain employees on the directory side, on the file side.
And that's very helpful to know. And as Chad said, the specifics and the ability to customize is really endless. But the point is that you have that level of control on even as Chad said, even down to the document level. And a lot of employers talk to Jim and myself about restrictive covenants and confidentiality agreements and what can we do to limit the use of information after employees leave. That's what we're going to talk about next. It's a very valid consideration. But the point is that the point of this discussion is that there are steps that you can take to significantly limit employees' ability to access sensitive information. Instead of having the entire company have access to what you deem your highly confidential, most often pricing information and customer lists, if you have a sales force, their list of prospects and their sales history, that type of information for most employers is what they deem most sensitive. And instead of giving everyone in the company an opportunity to use that for an inappropriate reason, you're limiting it to just the people who need it to perform their job. And that can be done on a department by department basis. And you also then, through policies, can establish that unauthorized access to this information can be grounds for discipline. The unauthorized access to information can also be used during litigation to prove intent to deprive the employer of this information when we talk about causes of action and civil theft remedies. So I know it may seem like an unnecessary step if everyone needs access to this information and it's creating needless hurdles or obstacles. It really is something to evaluate from a security perspective. And again, it's a proactive step rather than focusing on the litigation or the recovery efforts after, which are much more difficult, time consuming and expensive. You can do some housekeeping on the front end to address some of those issues.
So John, the one thing that I've seen a lot, even on the consulting side, is HR documents. You know, HR and even, you know, everybody doesn't want to know what everybody's getting paid. HR usually keeps something somewhere, some spreadsheet someplace, disciplinary files. And if those things aren't secured and anybody can get in there just by clicking on a directory and going through it, you don't want all your employees to see everything that's out there just for legal reasons, HIPAA reasons, things like that. You want to make sure that that stuff is secured. Whether you have it locally on a server that you own or whether you put it into the cloud on a Google Drive or a OneDrive with Microsoft, there are ways to secure those files and those directories that others cannot access or even see. And if you have problems with that, that's where I would encourage you to reach out to somebody, you know, on the IT side that can help you with that. I mean, Google and Microsoft, they have, you know, YouTube videos, they have anything that can help you set that stuff up. So, and then your local IT professionals are more than willing to step up and help you out.
That's a great example. Not only, I mean, the unfair competition and the loss of, like I said, pricing customer lists, there's also some confidentiality requirements that employers have to abide by. So that's another good reason to evaluate and protect certain information. So I alluded to it, but to talk now about what are the procedures or the options available to employers who've had information taken from them. You have all of your policies in place, but all of your handbooks should say this is not an enforceable contract. We don't want breach of contract claims against employers if they change benefits, and therefore we recommend that employers explicitly say this is not a contract, it's subject to change at the employer's discretion. That's pretty standard language in an employee handbook. But the flip side of that is an employer cannot then pursue an employee for breach of contract if they violate a policy. It's a completely legitimate basis for discipline up to and including termination, but it isn't grounds for a legal claim for breach of contract. You can enter into a contract that addresses these issues. You can't enter into confidentiality agreements that protect, again, confidential information. That has to be defined reasonably. These confidentiality agreements are subject to the reasonableness requirements under Wisconsin statutes, the same as non-compete agreements and non-solicitation agreements. But in a confidentiality agreement, you can set a timeline for confidentiality protection. You can establish provisions for injunctive relief and damages, and you can also have a fee shifting, an attorney fee recovery provision. So confidentiality agreements can be very effective when utilized for the right information and with the right employees. But a confidentiality agreement is not, I would suggest that a confidentiality agreement isn't a blanket approach or something that should just be handed to all employees when they walk in. I think it requires a more nuanced approach directed or based on the employee's position and the information that they have access to. The other protection that exists under common law, meaning no contract is required, but these claims just exist as a matter of law, they're torts, is the legal term. There's unfair competition, civil theft, and conversion. These are based on the unlawful taking of information that belongs to the employer and the use of that information in subsequent employer to compete against the prior employer. So these claims, again, exist absent any contract, but the policies that you maintain regarding computer usage and your information go a long way in establishing whether you have a viable claim for this information. For example, you have, as Jim said, a policy says that we own this hardware, we own the email account, and we own all the information that is communicated or transferred through the email account. Taking of this information constitutes theft or is taking of your employer's property. That establishes a property interest in the electronically stored information. You also want to establish those procedures and protocol for saving and deleting information. You have employees who, absent those directives from their employer, just go about and save and delete based on what they think works best for them or what they think is reasonable. And if they go too far, for example, in their deleting of information, they like a really neat inbox and they delete everything that's more than a month old, and you're trying to recover information that's 6 months old, but the employee says, this is how I do things, it's going to be hard to, or if someone leaves employment and half their email is gone and they say, I didn't know what I was supposed to keep or what I was supposed to delete, this is what I was doing. It's hard to prove intentional destruction of property or intentional taking. A lot of these claims have an intent component, and absent the policy or protocol from the employer, it's tough to prove that what they were doing was malicious or intentional. So when you establish that protocol, when you communicate that protocol, and then the employee violates that protocol, it's a much stronger argument to show that they were doing what they weren't supposed to do because they wanted to delete information or because they wanted to take information that they shouldn't have had access to. So to put a finer point on it in the form of a case example, this is actually a case that Von Briesen handled a couple of years ago. We litigated it last summer, tried it to a jury successfully. The background facts briefly: an employee is a project manager at a construction company, and he gives his employer 2 weeks notice that he's going to be leaving to go to a competing construction company in the area. And the employer, because he's a project manager and he's the point person on construction projects all around the country, the employer utilizes that 2 weeks to have that departing employee work with his replacement, get relevant information transferred onto the network, and bring the replacement up to speed on the projects that the departing employee is managing. On the employee's last day of work, he comes into work with an external hard drive. He plugs it into his work computer. He puts his entire email file onto the external hard drive, the entire contents of his email, as well as thousands of documents off of various project-related folders on the company network, related to contractors, subcontractors, pricing information. Takes all of this information, puts it onto his external hard drive, and then wipes the contents of his work computer, which contains a significant amount of information that's been stored locally on the computer, as well as all of his email files. The employer fortunately discovers what happened the day that the employee left. They start their recovery efforts immediately. They actually confront the employee via phone call after he has left, and the employee denies taking anything, says that he has been having computer issues for weeks, doesn't know what happened to the information, and denies that he has anything. So the employee was not under a confidentiality agreement or an employment contract. There was no option for breach of contract claim. He obviously had ended his employment, so the violations of the employee policy and discipline were a non-issue. However, there were those common law claims that I previously alluded to. Even absent a contract, and even though he was just under handbook policies, there were viable claims for civil theft based on his intentional taking of electronically stored information, which constitutes property under the law, as well as unfair competition claims and conversion claims, conversion being a common law version of theft. So the case was tried to a jury. We were able to, through use of a computer forensic expert, evaluate and analyze the hard drive and show to the minute when the external hard drive was plugged in, when he accessed his email account to drag and drop it onto the external hard drive, at what time he accessed various folders on the network, at what time he put all the information in the recycling bin, at what time he went into the recycling bin and deleted the entire contents. So from a liability and proof perspective, everything was laid out in black and white through a timeline that we were able to create through an evaluation of the hard drive. Obviously, that process was time intensive. The expert cost money. It was not a cheap endeavor. However, under the civil theft statute, we were able to recover investigation and litigation costs, including attorney's fees. So it was a very good outcome for the employer. They did some things very well. Again, the purpose of highlighting this is to provide some teaching points for the attendees here. They did some things very well. Their social media policy and their email usage policy clearly stated that the system was their property and that everything that was transmitted on the system belonged to the employer. It laid the groundwork for an argument that this, in fact, was a theft of property. Even though it was electronically stored, it was virtual, there was no physical property of any kind, it does constitute property under the law. The policy was very helpful in making that argument. Also, the employer's proactive recovery efforts to immediately send in the laptop, to have the hard drive removed from the computer and copied, was very helpful in allowing the computer forensic expert at a later date to go into the hard drive copy and again, create that timeline. That was very helpful. So policies were critical, and the proactive recovery efforts were critical. The missteps or the room for improvement, so to speak, from this case is that the backup procedures and the centralized storage procedures were not implemented fully and more specifically not enforced. So the employer was utilizing a server-based email platform, meaning that the employer managed the backup procedures and how often the backups ran, the protocol for where the computer being on the network so that the server could have access to the email account and back it up. And that system wasn't operating correctly. There was no email backup. Essentially, the employee's email account was the only copy of the email that the employer had access to. Likewise, the employer's protocol for having emails, project-related emails shared centrally on the employer's server was not being enforced. The project manager had a bunch of emails and documents stored locally on his computer that were never transferred or shared onto the company's server or their network, which was being backed up. And therefore, the employee effectively had the only copy of his email account on his computer, and the employee had the only copy of a significant amount of sensitive information that had been stored locally and maintained locally on his computer. So in this case, we're talking about an employee theft, which deprived the employer permanently of this information. But it could also be something less malicious. An employee in that situation drops their computer or has their computer stolen, or their computer just stops working, you're in the same situation as if someone stole all the information, if it is all stored locally on the computer. And when we get to keys to remote work security and how to manage information remotely, Chad's going to talk about why local storage is very problematic, and you're going to want to establish procedures and protocols to get the information from someone's remote workstation onto your network. And then finally, the employee had full access to information prior to his resignation. The employer was on notice 2 weeks before he left that he was leaving to go to a competitor. Now, hindsight's 2020. This employee obviously didn't say, I'm going to take information to go compete, and therefore the employer just assumed that he was going to be helpful in the transition process and not steal any information. It's a case-by-case analysis. When someone puts in a notice of resignation, whether an employer wants to curtail access to certain information in light of the fact that the employee will be leaving. It's an additional analysis if the employee is leaving to go work for a competitor. But to look back at the discussion that Chad had regarding applications and password protections, when you have those mechanisms in place, it's much easier to turn access on and off for a departing employee than it is to try and create those limitations in that structure out of whole cloth when you do identify someone as a sensitive employee and you want to limit that access before they leave employment.
Hey, John, just a couple points on that as you're working on the teaching moments is, and of course we have a different program about what to do when people are leaving and discipline and discharge, and I get that, but it's not a bad idea to remind employees that when they give the notice that the stuff still belongs to the company, and remind them of any confidentiality aspects. Again, we don't have to be real hard about that, but it's not a bad idea to just to remind them. Even before we get the notice, though, it's always good to have a view of what's going on. If we've got a process where people, and we're hearing about people using our materials, using our stuff, using our promotional stuff, using our training stuff in some other forum or some secondary employment, we got to get on that. We got to talk to people about that, and we got to forbid it to protect that material so we're not giving it away or having some history or practice of giving it away. Again, some other practical teaching moments that we can add as well in working on these kind of things.
That's a great point. And the reminder when someone puts in there, I think that's a great first step. Even if you're not going to turn off access, the reminder, even in an email format, as informal as an email, but you have it in writing that this information belongs to the employer, that it's not to be taken, or no information is to be forwarded to personal email accounts. It again provides a piece of evidence that if the employee does something contrary to the email notice, that it was intentional and with knowledge. And again, that helps in the recovery litigation if that's necessary. The next topic I want to talk about and have Chad weigh in on is email phishing scams. I think most people are generally familiar with the concept of a phishing scam or a phishing attack, and generally familiar with the concept of ransomware. Certainly the prevalence of these types of attacks is increasing, and it's happening locally. It's not happening to just the Fortune 500 companies. We're seeing attacks at all levels, and even in personal Gmail accounts. I'm sure some of us have red flagged some suspect emails. But just to talk about and give some brief background, Chad, so people have an understanding of what exactly this is doing to a computer network if you are clicking on this attachment. So just a summary on what is happening with a phishing scam where the goal is to implant ransomware.
So yeah, phishing scams are, they run the gambit. Some are just to get your username and password. Some are to, implant malicious code. The ones we've seen, earlier would be the ransomware stuff. Ransomware is the easiest thing that hackers can do because they don't have to do anything. They don't want to steal your data. They just want to provide or prevent you from accessing it. So basically, they'll send an email that looks like it's coming from either inside your organization or somebody you know that looks important, you know, something like the IRS or something, and they'll provide a link or a picture or something in there. You click on that, and then that executes whatever code they have in the background. The scary thing for the IT side is that nothing may happen right away. These guys are very smart. This code is put in and it sits on your local machine for a little bit. And then all it does is sit there and look around and see if it can get access to a network, a corporate network. And it uses the rights of the user that's currently logged in. So if you have rights to an open share, or if you have rights to your directory, your department share, and if, you know, say for instance, you have an HR person that has rights to multiple directories, it's going to sit there and look around and see what it can get access to. And then it's just going to sit and wait. It's going to be on your network and it's going to sit and wait, and it could wait. We've seen it wait up to 6 months. And then that timer expires, and then all it does is it starts encrypting files, one at a time, couple at a time. And then you don't know what's happening until somebody accesses a file that's been encrypted and they get the message. Then they usually call IT, and IT's got to go back and figure out where the encryption is. And by that time, you know, if you're lucky, you can go back and you can determine what file, when it started, and then you can maybe find a backup that you can go back beyond that date of when it started. But as I said, this could have been sitting around for 6 months. So you may put the backup back to the day before, you know, you notice the encryption and everything's fine, but that timer is still running on that file that got backed up, that is now back on your system, and you may see this again if you're not running, you know, anti-malware application or something like that. So once you get the system restored, then you need to, you know, scan your systems, make sure that, you know, this file that executed isn't still part of your backup, and delete it so it doesn't happen again. So even though you may have a backup, you may still be restoring that backup, which has the original file that is going to redo the encryption piece. And then if we've seen, you know, City of Oshkosh is one. I mean, they were hit by ransomware, and, you know, if it gets down to the point where it's all they want you to do is pay them, and then they'll provide you a key that will unlock your files. And usually it's a few $1,000s, depending. It all depends on what type of data it is and who it is. And, you know, if it's just a small mom and pop place, they probably won't, they'll charge you a considerable amount of money. But if it's a government organization, of course, they're going to see if they can get as much money as they can. So, and usually in the way they're going to ask for payment is Bitcoin, because it's untraceable. So that puts in another, you know, aspect of how do I get Bitcoin? Most of your IT consulting companies have some way to do that. They have, you know, cybersecurity specialists on staff. They have this. Is that ransom paid? I will say yes, it does get paid. In a lot of cases, it does, because it's the only option they have. Does it solve the problem 100% of the time? I can't say it does. Sometimes they'll provide you the key after they get paid, and the key may only do so many files, or the key may not work. In most of the cases, it has worked, but in some cases it hasn't. So you're still out the money, and now you're out your data. So don't think this is something that's really hard for these guys to do. It is the easiest thing for these hackers to do, is because they don't want to transfer all your files. They don't want to keep all that data. They just want to provide or keep you from getting it, you know? So it's easy for them to do, and then they just wait for you to send them an email or call them. So.
And the last point is probably the most important, is that this is not difficult to do. There are people attempting this all over the world, and all they do is sit around and think about ways to craft emails to get around the filters that
right.
the email systems have, and also ways to intrigue people to click on links and attachments, copy or trying to send emails from ownership of companies or the C-suite of companies, trying to disguise the emails as gift cards. And there are a number of very common approaches and some very nuanced and sophisticated approaches. But the most important point in all of this is that clicking on the email is the access point, and the clicking is, if it's past the filter and if it's in an inbox, the last resort for protection of your organization is the individual who has the email in their inbox. So training your employees, putting them on notice of this risk, and training can be as sophisticated as going through an actual online program and reviewing test emails and sending sample emails. At the very least, it should be a regular update and communication to employees that this is a risk, that if suspect emails are identified, they should be forwarded to a certain individual, and don't click on emails that you don't know who the sender is. But again, Chad, just briefly, what are some of the more sophisticated training techniques that employers could utilize if they wanted to actually test their employees' ability to comply with these instructions?
So some of the things that we've done is we've actually done, our own phishing attempts internally. We make sure that we've trained our users and our user base that if it looks suspicious in any way, delete it. Let IT know, but just delete it. Even if it looks like it's coming from somebody internally, if you look at the email address of where it's coming from, if you click on that email address, usually it's, the username at, thecompany.com. If you click on that and it looks nothing like that, it's a phishing attempt. It's a scam. Just delete it. We've trained our users to make sure to look at that. We've also trained our users that there's only, ownership and the C-suite communicates with, a lot of people. But there's some people that, if you get an email from an owner or something like that, it's out of the ordinary. So if what we've trained in our organizations and some of the organizations I've worked with is that if you're getting an email from, a CEO or CRO or the C-suite, email them back and say, hey, is this real? And they'll get back. And we've had several times where, the C-suite's like, oh my God, thank you for letting me know because I did not send this email. But unfortunately, it's just a matter of keeping your guard up. Once it gets into your inbox, it is the user who protects the company because it's just, unfortunately, we have to be very worried about every email we get and be suspect of it, unfortunately. If it's not somebody one thing we tell everybody is like, if it's a scam email, if you think it is, just delete it. If it's not, they're going to email you back and probably, chastise you for a little bit for not getting back to them. But, if it looks weird, our instruction is just to delete it and then just move on, let IT know, or they'll get an email and shoot it over to IT and say, hey, is this a scam or is this something I can click on? Unfortunately, what it has done for us, so for some of the C-suite and some of the IT people is when we do send out emails, we have to actually put in there, this is an okay email, you can open it. And then we still get calls because it's like, is this a real email or is somebody telling me that you're IT? So it does make things a little bit harder, but it just shows that our user base is learning and becoming more adept at it. So all you can really do is just train your employees to delete it if they don't feel comfortable with the email at all.
And I know Chad has a hard out at 8:55, so I want to utilize him while we still have him to go through and switch the discussion to remote work security, an issue that a lot of employers have been dealing with for the last 6 weeks, and I envision they'll be continuing to take a closer look at it now that there's been some evidence that employees remain productive and you can manage it if done correctly. But if an employer has not already or is experiencing some growing pains through going through remote work, what are the top 2 or 3 concerns or issues that an employer should focus on if they want to transition someone from what was previously in the office job to a remote work location, from network to software to hardware? What are some of the primary concerns?
So the biggest concern from my standpoint is allowing a worker to go home and use their personal work computer, their personal computer at home to access company resources. Unfortunately, for IT, we can't control that. We can't, put software on an employee's personal computer and manage it and things like that. We don't know who's on it, if they have kids, what sites they've been on, things like that. It could have malware, it could have whatever So the biggest thing is to make sure that in order to secure your network remotely is to provide some type of mobile device that allows them to get access, that employs a virtual private network client, which what that is it's a piece of software that sits on your computer, your work computer. And when you connect to a Wi-Fi, you launch this software. It connects to your corporate network through a VPN device back at the corporate office and encrypts the connection between the remote computer and the network. Basically, nobody can see the traffic being passed in between your computer and that computer. It also, depending on how your IT department sets it up, if you're sitting at a Starbucks and you use Starbucks Wi-Fi to get onto your corporate network, if the IT department has set it up so that all traffic from your computer flows through the VPN, you're completely secured. So even if somebody were to jump on your Wi-Fi, they're not going to be able to see and what we call sniff that traffic or watch that traffic flow and capture any of that data because it's all encrypted. So VPN is very, very, very important if your company employs it. If not, you know, they're pretty easy to set up, pretty cheap solutions to put in place as well. The other thing is, like I said, having remote devices that are managed by your company at those remote locations. We know that that can be cost prohibitive, but if not, I would have the IT staff or consulting firm have somebody go over there and check that computer that the employee is going to be using and make sure it does match what you need from a corporate security standpoint. Does it have antivirus on it? Does it have an anti-malware? You know, are all the patches up to date? And are they using, you know, is their Wi-Fi at home, you know, secured and not just wide open? Things like that you should really take into account.
And you should still encourage employees to limit the use of their computer for work reasons. I mean,
yes.
You're concerned about not using a personal computer and therefore you're providing a company computer. Well, you mitigate some of that protection if all of a sudden the work computer turns into the kid's school computer, turns into the weekend shopping computer.
Right.
You really want to, it's important to have that policy as we discussed, and also enforce it, because every non-work related use or every non-work related download creates an opportunity for a breach.
And in most cases with remote computers that are managed by IT, most of that stuff is pretty much restricted. I won't take it down to like a Chromebook, but you know, IT can put in things on there where you're unable to download applications from the internet. They can restrict certain sites going to the internet as long as they're using the VPN. But yeah, having the company control that resource is a lot easier and more secure than having another resource, you know, at home that isn't controlled, for sure.
Right, that's a good point. Limiting where that machine or how that machine can be used, again, is within the employer's discretion. And when you pay the cost to have the hardware, you get with that additional control and security.
Mm-hmm.
Well, that sounds good. I want to be respectful of Chad's time. Thank you so much. I appreciate you chiming in and participating this morning. It was very helpful and informative.
If you guys have any questions or anything, please feel free to reach out anytime.
Sounds good. And again, the name of your consulting company?
Livewire.
Sounds good. Thank you very much.
Thank you, guys.
I think we have 5 minutes left here. I have one question. Will we be able to download the PowerPoint? Yes, we will be able to circulate, I think, a recording or at least the PowerPoint to the participant list. We'll coordinate that with the chamber. I will keep an eye out for any other questions. Please feel free to ask them if you have them. I will take the last 2 minutes to give Jim an opportunity to address remote work policy. With remote work and having employees outside of your physical location comes with it some concerns about when people are working, how people are working, and how that time is being tracked. Another opportunity for a policy.
Well, right, and as we look at all of these things, a lot of people, we work with a lot of people over the last couple of months on remote policies and how we do that, but wage and hour issues come together, so we want to know what schedules are. We got to track when people are really working as the PowerPoint suggests here, there's confidentiality aspects, so we got to protect all of those things. So I know we got a limited time and I don't want to go other than, you know, as we look at the whole program today, for both thanks to John and to Chad, certainly, but it tells us a lot of things. There's so much you can do to help your company up front on a much less expensive basis by doing go back and re-audit your policies and put in these protections. Go back and re-audit your contracts to see, do you have some things in place, or should you put some things in place that'll help with a contractual piece later if we ever need that. So we don't get in, if we get into the litigation, we want to be in the best possible position to protect the company's interests. But again, a lot of what you guys talked about today, a lot of the suggestions and practice points had to do with preventative stuff up front with a little bit of investment. The other thing I can add is just good resources like Chad's companies and others that are good chamber members that are local, that help a lot with a lot of these things. We don't have to go to other parts of the state or other states for that matter to get really good, effective services here. So with that, I'll come back to John Casper a little bit, but many thanks to Chad, to John Iden, putting this together, their background and the other pieces. John, I just make one other plug, John Casper, one other plug for tomorrow's program, which we had scheduled a couple of weeks ago that just got real interesting based on yesterday's decision.
They say timing is everything. So sometimes you hit it right. Yeah, it's going to be an interesting next couple of days. A lot of moving parts. We've been kind of communicating back and forth while this is going on to you know, not just executive members, but also city manager and also the county executive. And you know, it appears they intend on creating a policy to replace the safer at home order that was just lifted. So stay tuned on that. We're getting a message out to our members shortly on that, but we haven't heard the last. So with that, I mean, I would recommend as many people tuning in tomorrow, 11 o'clock, talk about returning to work and things you can do. So we thank everyone for joining us. Jim and John, thanks for putting the program on again, and we'll hopefully do one again next month. And we're done for the day. So thank you very much, gentlemen. Take care.
Welcome. Bye
Thank
now.
you.